Don West, National Trial Counsel with CCW Safe. Today we're going to talk about interacting with the police during an arrest. The way you conduct yourself during an arrest can significantly affect how the police view you, and it can impact how the prosecutor and judge view you later on. If you get arrested, don't argue or become combative or threaten to sue the police for false arrest. You can express your indignation to your lawyer, and if you have a case for false arrest, he or she can pursue that later. If you are respectful and polite, you will help establish from the beginning that you are not a hothead, that you can control your emotions, and that suggests that your actions in defending yourself were reasonable, rather than the product of wild panic, anger, or revenge. Even though you may very well know your rights, it's probably not a good idea to remind the officer and warn him that he better not try to violate them. Bad manners will do you far more harm than you may think, and the only thing that will really matter is whether you are seen to have acted reasonably or not at the end of the day. Don't start off on the wrong foot. When you are placed under arrest, you are in custody. That means you are a prisoner, and if you resist, even an unlawful arrest, you can be charged with another crime. If you try to run away, you can be charged with escape. If you struggle with the officer, you can be charged with resisting arrest. That's a fight you will always lose. Any of these actions will make you look bad to a judge who has the power to grant or deny bail, and to a prosecutor who may decide whether to formally charge you with a crime or not. Sometimes the police will temporarily detain a subject by handcuffing him, putting them in the patrol car while they sort out what happened. It's possible, but frankly not likely, that a detained person will be released later. Once a person is formally arrested, the speedy trial clock starts ticking. That means that the case is on a timeline, and that can affect how thorough the police investigation can be. Due to backlogs in most forensic labs, a premature arrest can even affect whether certain evidence can be analyzed in time for court. If you're not arrested at the beginning of the investigation, that doesn't necessarily mean you're off the hook. It might mean that they need more evidence before they make formal charges. During this time, it's a good idea to find a lawyer. Once you're turned over to the booking officer, you will be photographed, examined for medical problems or other risks, and then classified for bail. While people with some charges are able to post bail at this point, when there's a homicide, don't count on posting bail just yet. You're going to have to prepare for a bail hearing, and we'll talk more about that shortly. After you're booked, you'll be placed in a holding cell away from the general population. The jail does this for their convenience, since you'll likely be going to court the next day, and also to keep an eye on you until they know whether or not you'll be staying a while, and of course whether you'll adjust. You'll probably sleep in your clothes, unless they've been taken from you already to be examined for evidence. In the jail, it will be loud, cold, hot, or all of them, and there will be lots of hard surfaces to sleep on if you're able to get any sleep at all, and of course you can forget flossing. The next day, you'll look as bad as you feel. However, you'll be much safer than you think. The chances of being assaulted are really quite low, especially at this stage of the case. The horror stories people hear about being sexually assaulted, beaten up, or having one's possessions stolen occur pretty rarely in county jails. Those are the stories you hear from the prison system, which I might remind you is a good place to avoid if at all possible. Well, thanks for watching. I'm Don West for The Next Fight.